Go to any family court and you'll find the dockets overflowing with cases involving parents in dispute over their property, money, and children. Lately, most of these parents are self-represented, trying to navigate a complex and frustrating legal system on their own without a lawyer. Today on Family Matters, an introduction to family court. Every day, family court judges like myself try to make the best decisions we can, even though many of the parents coming before us are self-represented, which means they don't have lawyers. And a lot of these parents make messes of their court cases and of their lives. That's why I decided to dedicate this episode of Family Matters to giving you an introduction to family court. We'll hear from two lawyers and one of my fellow judges who will tell you what you need to know if you might be headed to family court. Our first guest is family law lawyer Lorne MacLean. Lorne, welcome back to the show.
Thanks for having me.
I understand that in your practice you go to court a lot.
I'm known as a courtroom litigator, that's correct.
It's, I think, fair to say that of the millions of people who break up, only 5% of them go to court. That's what the experts tell us. That's true, and as a lawyer, that is also only a small part of our job is going to court for our client. We try to keep our clients out of court as much as possible. There is no shame in a fair settlement. It's always preferable, but some matters just have to proceed to court. So, I think it's always a surprise for people to find out that it's a very small percentage of people that actually litigate in court. What kinds of cases should be in court? All right, well, you've got three types of litigation personalities. First of all, there's the doormat or the hero, and those people will make a settlement at all costs. And like the old Fram oil filter commercial, you can pay me now or you can pay me later. These people don't want to hire a lawyer. They just want to end it. They feel guilty, for example, if they've had an affair, or they feel downtrodden if someone's cheated on them, and they just want out. And that's the person that we have to prop up and support so that they don't make a bad deal, that 3 or 4 years down the road, they try to come back to fix, and they can't because a deal's a deal. Second type of litigation personality is, I just want what's fair. Hopefully you get two people like that in your family case and you reach a settlement. The most dangerous type of litigation personality for going to court is the I want vengeance, I don't care what it costs, I would rather pay my lawyer. If you get two clients that have that mindset, you're going to have litigation, and those are the people that will be in court for a long time. Those are the high conflict personalities that can clog the court system. And they never say, I want vengeance to the judge. They say, I want justice. But justice is often defined as vengeance. And what about the kinds of situations? You know, we often say to people, family court should be your last resort. But there are some situations where you may need to go to court legitimately, not because of a personality issue, but because you need the services that a court can give you. Exactly right, Harvey. Personal protection orders, for example, domestic violence. Everybody is now so much more aware of just how damaging domestic violence is, not only to the spouses, but also to the children that part of it. So when you've got a victim, that person's hurting. The child that's either been hurt or witnessed one of their parents being hurt is also damaged, but just as importantly, the perpetrator of that violence, the sooner we can get that person help, the sooner we can try to make this family whole. Because so one of the reasons you would go to court is for safety. If you need a restraining order, a protection order, you got to get to court. Right. There's another, and I call it if there's a mental health problem. Right. You've got mental health issues where people need to be encouraged to look in the mirror and try to keep their side of the street clean. Most people would like to blame the other spouse for what's going on. There may be drug issues, there may be alcohol issues. You know, if you're an addict, the easiest person to fool is yourself. And if you're dealing with someone like that on the other side, you may not be able to negotiate. You may need a judge to just make an order.
We need a judge to make an order that protects the child until that person recognizes the issue. If they don't, then that child needs to be protected. If they do, then we can put some interim protection in place with some ways for reducing the restrictions on them if they pass a number of drug tests, for example, if they say they're going to AA, if they get counseling. We want to make these parents healthy. It's not just about sort of trying to hammer someone that we say has been bad. That's not what the court system does. I know a lot of clients think that's what it's for, and they're in for a rude awakening when they go into court.
And then there's the people that are unfortunate enough to have an ex-partner who just won't deal with them. You know, you've been ejected from your home. You may have to go to court.
Well, that's the person that doesn't think they should pay spousal support, for example, after a 30-year marriage where their career has flourished and the other spouse has no career, and they think for some reason that person can go out and get a job. It's simply not realistic. A person that says you shouldn't see your child at all, when we all know that having a good relationship with both parents by a child is a good predictor of a healthy child growing up to be able to have normal relationships. So if you get an unreasonable person on the other side, you are forced to go to court because there's no downside. You are only going to do better than what that person's trying to give you without going to court.
A lot of people say that they don't think they need a lawyer. In the jurisdiction where I preside in court, 72% of our litigants are unrepresented. They do not have lawyers. Can you tell our viewers why is it so important to have a lawyer if you're going to try to resolve a marital breakdown?
People need to understand that if they go to court without a lawyer, they're going to compromise their settlement. They're going to compromise their rights. They're going to compromise the needs of their children.
And family court's complex, isn't it?
It's very complex.
There's rules of procedure.
Rules of procedure.
Evidence.
If a person walks into court all emotional and all wired up, they're not going to be able to gift wrap an argument up in a Tiffany's box. They're going to end up dumping sort of a garbage can of arguments in front of the poor judge and trying to get the judge to pick through it. Now, which would you pick as a judge? The little Tiffany's box argument or a big garbage can that you have to dig through?
I would look through both and try to get the best evidence and make the best possible decision. But the point is, you need to go to a lawyer. Thank you for being on the show, Lorne. When we come back, we'll go in chambers with lawyer John Schuhmann. Stay with us. Welcome back to our discussion of family court. We're now in chambers with a lawyer who's written a book that attempts to explain complicated family law principles in plain language. His name is John Schuhmann, and the name of the book is A Guide to the Basics of Ontario Family Law. John, welcome to the show.
Great to be here.
Tell me, John, when a client comes to see you, how do you help them decide what kind of strategy they should be using to resolve their marital disputes?
Well, I listen to their story and what's important to them first, and I get a feel for where they are and in their life and what they want from seeing me as a lawyer.
So if someone tells you that their breakup was amicable, I take it that's a very different approach you're going to take than if they tell you that there's a serious conflict, a big dispute going on about money or children.
Yes. I mean, people have a whole range of ways to resolve things. At the one end, people can sit down at their kitchen table and work it out with their spouse and go to a lawyer and make sure it's all okay and get the lawyer to write it up so that it sticks later on.
But some people, I think, assume that if they're going to a lawyer, they're going to start a battle. Do you review with them when it's appropriate to start a court case as opposed to try something more negotiating-like?
Yeah, I think it's important to go through all the options, and court is only one of the options. There's a whole range, and one of them is sitting at the kitchen table, the other is going to court, and in the middle, there's a whole range of choices that people can choose from.
So when would you recommend a court case?
I recommend a court case when the person comes and tells me that their spouse is hitting them, their spouse has got some sort of mental health concerns, and it's not just like they're saying it's a mental health concern, there's actually like some evidence there's a mental health concern. Or that their spouse is...
Maybe violence?
Violence is the other one.
Domestic violence, abuse, substance abuse,
mental
health problems.
Those are the main times when you need to go to court.
When you hear things like that,
Yes.
That's when you think, okay, I better get to court.
That's right.
Now, you mentioned something important about proving it. They can't just say it, they have to have some kind of proof. What are you looking for?
In court, what you say doesn't matter. What you think doesn't matter. It's what you can prove that matters. Because judges hear from two sides all the time.
Tell me about it. It's so true, and we don't know what's really happened. What you can prove happened is what we look at, because you need evidence. So it must be very frustrating when you tell a client, look, you know, you say he's been abusive, or you say he's a drug addict, or she is mentally ill, or whatever, and there's no proof.
That's right, because really we need to show a judge, those are all serious allegations, and if you want a judge to act on a serious allegation, you want a judge to make a serious order, you really have to prove what you're saying. Because judges hear all the time that a person's spouse is crazy, or they can't stand them, or this person they live with all their life is somehow now a complete wingnut.
Now, you know that most people that do go to court, and we are talking here about family court, seem to be very dissatisfied with the process. That's my perception, that they don't find that the process is fast enough, it's too expensive, and they find it too stressful. Is there a way that you, as a litigator, determine what kind of strategy you're going to use in terms of being aggressive or not so aggressive with court cases?
Well, I listen to my client to start off with, but it depends on the case and what the client wants to get out of it. I mean, some people don't need a big fight. I mean, there may be some small issue they disagree about, and you know, there are other ways to resolve the small issues. If there's a serious, you know, child's in danger situation, if there's a chance that a parent's going to run off with the child, then we're going to court.
What about issues that have to do with money? The parties really seem to be able to deal with the child care, the parenting plan, well, but they don't agree with money. Somebody wants spousal support, the other one doesn't think they should have to pay it.
Yeah, it's kind of funny. There are very few financial emergencies. There's very few times you have to run off to court on a financial matters emergency. I remember hearing a court yelling at his client who called him on the cell phone, a premarital deduction is not an emergency, right?
But when you do go to court and you've decided, okay, I'm going to have to bring a court case, when is it appropriate to get aggressive and really push for a hearing and really ratchet it up? And when is it appropriate to try to resolve the matter in a way that's not involving a judge deciding it?
Well, my experience is that clients are almost always happier when the judge doesn't decide it. So it's when I ratchet it up, when I'm going to court and fighting it out, is when I've tried to settle it beforehand, and the other side is saying, you know, you're not getting a dime from me ever, or I'm just not going to listen to you ever. That's when you need to go to court.
And what if the other side doesn't have a lawyer? I think you're aware that in most major centers, people are unrepresented. They don't get lawyers. How do you handle a court case if you're representing your client, but the ex-spouse is representing themselves?
When I'm there, and even sometimes the judge is there telling that unrepresented party, look, what you're saying doesn't make any sense. And they're saying, no, it's what I want, it's what I want. And you're saying, no, it doesn't make any sense. And the judge is like banging his head against his desk, and I've got my hands thinking, oh my God, why can't they just get it? And that's when we end up having trials, because we've got one side that just doesn't understand the law or understand what's fair. And that's when I end up going to court or having the big fight.
And I think many people don't realize that if you are being unreasonable in court, you can end up having to pay the legal costs of the other party.
Yeah, that's actually really important. And I think as a lawyer, it's really important that judges do that, because
it makes people understand that there's a consequence to bad behavior.
Yeah,
and being unreasonable.
And you're running up your spouse's costs and making them pay thousands of dollars. The cases where I've done that, yeah, that spouse who's run up the costs because they don't have a lawyer, they end up paying my costs.
I hope everybody was listening, because that's a very important point. John, thank you very much for being on our show.
Okay, thank you.
Coming up, we're going to hear the perspective of a family court judge. Don't go away. I'm in chambers with my colleague, Justice Robert Spence, who has been a family court judge for 10 years. I know it's rare for a sitting judge to appear on television, Justice Spence, and I'm very grateful to have you here.
I'm delighted to be here, Harvey.
Thank you for taking the time to give our audience real insight into how judges actually do their jobs. As you know, most of the people that come to court are frightened. Most of them don't have lawyers, and they don't really know what to expect. What do you think is the biggest misconception about family court that people have?
I think that people who have never been to court before expect it to be like what they've seen on television, frankly. That's where people are educated about what's going on out in the world. So if they watch a show like Judge Judy, they think they're going to come into court, they're going to tell their story, and the judge is going to listen to the other side, and in 10 minutes she'll make a decision, the case will be over, and that's it.
And they never seem to have to prove anything on those shows. There's never any discussion of real evidence.
And it's very entertaining, and I can tell you it's not entertaining in my courtroom at all.
There's a lot of pain, isn't there? We see a tremendous amount of human misery and sadness. How do you deal with that?
So people have come from different experiences when they come into the courtroom. There are drug issues, substance abuse issues, there's infidelity, and you have to be sensitive to all of those issues when you're talking to people and try to focus people on the issues rather than on their own sort of personal agenda, if I can put it that way.
Well, how do you do that? You know, I mean, it seems to me that people are so wrapped up in their own pain that they sometimes lose sight of the fact that they're there to talk about a parenting plan for their children.
So a judge that I know once told me that in order to get them to focus on their children, he says to the parents, "Do you have a picture of your children? Show me a picture of your children." And inevitably, they both pull out pictures from their wallets of the children, and that helps them to focus on what they're in court today to deal with, rather than their own personal issues.
I know that judge very well.
Yes.
But still, I find, and one of the most frustrating things for me, I wonder if you agree, is that many of the litigants, the parents, come out of court more angry with each other than they were when the case started. And I feel that our job was to try to help them make peace, but the process itself is so adversarial and gets people so into the mode of slinging mud at each other that a lot of that mud sticks, and they're in pain for years afterwards when they're supposed to try to get along.
I agree with you, and there are a number of reasons for that. Some of them are institutional because the rules are difficult, the processes that people have to go through are complex. They find themselves over their heads in deep water. If they have lawyers, they find they're spending lots of money on the lawyers, far more than they had expected to originally. If they don't have lawyers, they're finding that the judge may be chastising them because they don't know what they're doing. Well, what do you have to say about that, about lawyers? It is a fact that the majority of people that come to family court in most large centers don't have lawyers. What do you say to those people? We find that more and more people are coming to court unrepresented. And the jurisdiction that I'm in, it's probably about 70 to 80% of the people. And I tell people, you've got to get some legal advice before coming into court. I know it's expensive, but even if you can go and sit down with a lawyer for a couple of hours and get some direction, you're going to be a lot better off than coming in here and not knowing anything about what the rules are, what it is you have to prove, and what it is you need to tell the judge.
I find it quite a challenge to explain to people that they need to be able to prove the things that they're alleging, that it's not enough to just get up and tell your story and trust that you're going to be believed when you have no proof.
It's a challenge. When self-represented people or unrepresented people come into my court, I've got a mother on one side typically, a father on the other side, and so I start off by saying, "What can I do for you today?" That's often my opening line. And the mother will say, or the father will say, "Well, I'm just here to get custody of my child." Like they're walking into Walmart and they just want to pick up a can of beans off the shelf. And
we don't even meet their children, except in the rarest of circumstances. We don't know these people, we don't know their children, and they often give us very little information about their children.
Exactly, and they don't understand that we have a legal test that we have to follow, what's in the best interests of the children. We have to go through a whole process of figuring out what the child is about, what the parents are about, what the parents are providing for the children, and where would the children ultimately be better off. What's in the best interest of the children? We can't decide that in 5 or 10 minutes.
Have you ever had cases where both parents were so negative and so accusatory towards each other that you were uncomfortable placing the child with either of them?
I have indeed, and it's very sad when that happens, and that tends to happen when parents come in and they're fixated on their own issues, which is not an uncommon experience. The mother wants to get back at the father wants to get back at the mother, and unfortunately the child is nowhere to be seen. They're not talking about the child, they're not focused on the child at all.
And what I often say to parents is that I get to decide who I believe with all of the things you're saying to each other. If I were to choose to believe you both, neither of you would be suitable parents, and your child could end up in foster care. And that is one of the main points that we're trying to convey, is that custody cases are not games. This is serious, and you have to put your children's interests before your own. Justice Spence, thank you very much for being on our show.
Thanks, Harvey. That was a pleasure.
I'm Lorne McLean. Today on Q&A, our question is, I have a family trial next week. What can I do to help me win? As a senior family lawyer, I'm often asked by my clients to tell them my secrets to success in family court. First of all, hire a lawyer, because studies show self-represented litigants get stuck in family court longer and obtain poor results. Here are 4 key tips to increase your chances of success in family court. 1, frame your argument as a positive solution to the problem for your child and both parents, instead of demanding justice or asking the court to punish your former spouse. 2, focus your argument to create a tiny, perfect Tiffany's box with an attractive bow on it, instead of dumping a trash can of useless arguments on the judge's bench, forcing him to pick through it to find the good stuff. 3, don't demand your rights. Good parents don't demand the rights. They know they have obligations and responsibilities. Remember, children have rights to see and have a healthy relationship with both of the parents. 4, remember each of us is 100% responsible for our 50% of the problem. Judges appreciate people who can look at themselves in the mirror and see what they can do better as ex-spouses and separated parents.
Thanks for watching. For extended interviews and exclusive content, please visit our website at familymatterstv.com. If you'd like to submit your legal question to our Q&A, go to advicescene.com. I'm Justice Harvey Brownstone. See you next time.